attorneys.
Good afternoon.
Your panel consists of the Judge Friesen, Judge Davis, and myself, Judge McClarity. You're welcome to the Court of Appeals. I've been informed that the appellant has reserved their rebuttal. Is there anything we need to, any motions, anything we need to consider at first, Ms. Lindsay?
No, Your Honor.
In that case, will you call this case, please?
Roger Dale Grice versus Don Marie Grice.
Very much. We're going to proceed in this case as if you were both in court, except you will not need to stand to make your presentation. For the appellant, are you ready to proceed?
We are, Your Honor.
Right ahead.
Thank you, Your Honor. My name is Daniel Bryant. I'm an attorney with the Montgomery County Clarksville Bar. I represent the appellant, Roger Grice, in this case. It's an honor to be here. There's really just one issue that was raised by Mr. Grice. This was a divorce case, a fairly long-term marriage, a little over 20 years. Both parties had been in the U.S. Army for significant periods of time. A lot of their service overlapped with each other. The wife was in service for about 16 years. Husband was in service for about 22 years. Wife's entire service overlapped with my client, the husband, now ex-husband, and about 16 years of his service approximately overlapped with the marriage. The trial court judge issued a ruling that the marital portion of the military retirement would be split 50-50. Now, we are not disputing the marital portion. Each wife was awarded 37% of the marital portion, husband 37% of the marital portion. That's a even 50-50 split. And so there is no issue as to what was marital versus what was not marital. The only issue that we have with the division is that our position is that it was not an equitable division of military retirement. Now, we acknowledge that probably the most common way to divide military retirement is to take the marital portion and simply divide it in half. And that's exactly what the trial court did in this case. Now, in doing so, the judge did what's frequently done. However, we believe that some of the unique parts of this case lend itself to a different division of the military retirement. And we acknowledge that, like most family law matters on appeal, it's really an abuse of discretion standard, and I understand that's a fairly difficult hurdle to overcome on appeal. It's a tough standard. Nevertheless, we feel like we may have it in this case. Starting with the general and working down to the specific, although our statute says we're to make equitable division of marital property, equitable doesn't have to mean equal. We cited a case in our brief where parties had agreed to divide military retirement with the non-service member getting 100% of the retirement. And the trial court approved that. Now, trial courts have the duty to approve a settlement as equitable, just like they have if it's contested and goes to trial. And the Court of Appeals upheld that, saying, yeah, it's equitable to award 100% in that case. And so the inverse is also true. If you can award more, even 100% to the non-service member spouse, then certainly awarding less is also equitable at times if the facts warrant doing so. And
how would that balance out with the TSP being awarded, her TSP being awarded, 50% to you?
Yes, that's exactly right. Wife's TSP was valued at time of trial about $47,000. That it had entirely accrued during the marriage, and the trial court judge split that 50-50 between the parties. That's correct.
Okay, so that wouldn't that be about the same thing then?
It would be, I'm going to say no, and this is why. TSP is a set value. TSP is a set amount, $47,000. Whereas a military retirement, a pension, is an ongoing amount. So whereas at the time of trial, TSP might be worth $47,000, which it was, 10 years from now, that's $100,000 of military retirement going to ex-wife and going to ex-husband. 20 years, that's $200,000, possibly more given COLA increases, cost of living increases. So the nature of a pension is just different than a set value TSP or other type of investment account such as that.
One other thing I didn't really grasp, what is the situation? Why would he award half of her TSP to you, and then on your TSP, which was granted, what valued about $3,000?
That's correct.
He did not make an award to her in any percentage from that?
The trial court did not award any percentage of that. The trial court did not really place a value on husband's TSP. Now, it was a fairly low value, but there was no value placed on it, and it was not divided. It was awarded entirely to husband. And that leads me to the next point. Part of making an equitable division is valuing things. Even in circumstances where parties agree on dividing certain things like personal property, which is hard to value, granted, but in order to make an equitable division, we have to know what things are worth, or at least have some estimate of what they're worth in order to grant it, not grant it, divide it, divvy it up, however. And in this case, we've attached to our brief our, as required by the rules of procedure with the appellate court, what was valued by each party and what was determined by the court. And looking at that graph, and which was based on the proof and based on the ruling, there were a lot of items of property and debt that weren't valued by the trial court. So if we go through that list, I'm not going to bore everyone with individual items.
Are those in the issues that are raised? Is that to be considered by us?
We're not disputing that the division was correct of those things. However, to make an equitable division of property, you have to look at it in the entire scheme of property division. You can't take, 2 apples on this side and say, we're going to divide those up when there are 4 oranges on this side that we're not considering. We've got to look at the totality. And so you've got to value each and every item of property to make sure it's equitably divided. Without that valuation, we can't do it.
But the only issue that you've raised in the brief, though, that you're saying that the trial court incorrectly split or divided was that monthly military retirement.
That's
that
correct.
Was split 50-50, and you're saying it should not have been because?
Well, one, we'll move on from the other things weren't valued, so we don't know. In this circumstance, the trial court went through the individual factors as they're supposed to of dividing property. However, the first big issue with the trial court's analysis there is that although she mentions each factor and puts facts to each factor, the trial court doesn't say in any capacity whether that supports a 50-50 division, whether it supports some other division. So although there are findings of fact, there are no conclusions of law other than the broad sweeping, we're going to divide it 50-50. Each of those factors have to be tied to some conclusion of law, whether that supports a 50-50 division or supports some other division. And so looking at some of the specific factors in this case, for example, factor 2, and that has to do with, the trial court found that both parties, although having physical diagnoses, had contributed to each other's success in the military. But there were no facts to support that. Although wife, she's in for 16 years and gets out, that means no pension. My client husband is in for 22 years. Yes, there's a pension. The trial court made findings in those factors that somehow she contributed to husband's retirement, but that was a conclusion not based on any facts. There were no facts cited that in any way did she support his career. And on top of that, one of the other, what we deal with here frequently in dividing a pension, especially a military pension, is that the argument is, well, it's equitable because one party sacrificed their career. They stayed home with kids. They couldn't get jobs. They had to move around. They went to Germany. They went to Korea. They were home when the other party was deployed. We don't have that here. We have two fairly situated, similarly spouses who were both operating through a career with the Army, and one who had the longevity to make it past retirement age, and one who could not pass a physical fitness test and was discharged. So there's no facts to support an equitable or an equal division. And we're not necessarily saying there should be no division of it, but certainly not equal. There's just nothing in the record to indicate why it would be essentially fair, equitable to give ex-wife half when
Why is it equitable that your client should get more than half?
Right, because it was his career that led to it. One of the factors specifically in the statute is each party's contribution to the assets accumulated during the marriage. And if wife is doing a similar career, but does not accumulate a pension, and then husband, similar career, makes it through and does accumulate that pension through his own work and his own efforts, then he has contributed more than wife did in that scenario. And so it is equitable to give him more than half.
But the same does not hold true for her accumulated TSP.
I can't speak for that. It's not an issue before the court. That was divided half and half. If that's not on appeal, essentially, I really can't argue one way or another there. I don't know. 28 seconds. There's a big part of, I'll say this is my last point before time is out. A big part of the statute, one of the first factors is the financial needs of each party. Wife going to school, only 90% disabled, can work, can continue to work, whereas husband had not worked in a number of years and is listed as a 100%. His ability to work is far less than wife.
Thank you, sir. Yes, ma'am.
Good afternoon. My name is Sherry Phillips. I did not try this case at the trial court. I'm sitting in for Sharon Massey Grimes, who has been appointed as the General Sessions Court pending her husband's demise. So I was not privileged enough to be at the trial of this matter, but I have reviewed the documents, and I think what Mr. Bryant keeps hindering on is the fact that Mrs. Grice did not finish the military, so she doesn't have a retirement. But she didn't just quit. She had a medical condition. She has osteoarthritis and a number of other, I think she had an injury in the military. So she's out of the military involuntarily because of her medical conditions. So she did sacrifice as well. She is going to school and trying to better herself. And all through Mr. Bryant's brief, he talks about the husband being unfixable because of his executive functioning problems that he has through the military. But at Exhibit 9 was an evaluation, a neurological evaluation, and it specifically says the patient, being Mr. Grice, may also want to reduce his marijuana intake, as research has found that prolonged use can negatively affect processing speed and executive functions. Further, the evaluation stated there is no evidence that the patient would be unable to learn to go to on to acquire a new skill or college degree, such as a culinary school, which because it's a hands-on, or a vocational school. So he says he's unable to work, and that she has earned a degree since. So that's one of the reasons why it's not equitable for the court to award a 50-50. And I disagree with that. The proof at Exhibit 9 shows that Mr. Grice can earn a living. Now, he also talks about the court went through the factors that she's required to do, and specifically went through each and every factor. Appellant states in their brief that because there's not a value on retirement, but this is not a retirement that we can go and we can pull a statement and say, oh, it's worth $47,000 like the wife's TSP. And when we're talking about the TSP, the husband had a TSP, didn't bring his statement to court, and was evasive about the value. But I think everybody agreed that it was a very low value, less than $3,000. So because she didn't have a value, and because it was very low, that's why that particular TSP wasn't divided. But there was a value on the wife's TSP.
School me on a question I have about this retirement. Does it terminate at the death of the husband? The retirement?
I am not certain about that. I don't know the answer to that. There is a survivor benefit, an SBP that can be paid. The record did not specify whether that was selected in this matter or not. If they didn't select the survivor benefit portion, then it would terminate at the death of the husband.
Okay.
But I do not know the answer to that as I sit here, and I apologize for that.
Well, that's okay. The reason I asked that, because this retirement cannot be determined as far as a set dollar value, can it, or can it?
No, it cannot. And the courts separate retirements all the time, pensions, and nobody knows the value of what the pension is. Nobody knows how long either party's going to live, or if their demise is tomorrow. We just simply don't know. But the case law specifically says that pensions, no matter if they've matured, if they've vested, they're unvested, if they've matured or unmatured, pensions or retirement, such as military retirement, are specifically marital property. So, and even though we can't put a value on them, the court finds it every day that it is appropriate to divide those. And the distinction in the case that Mr. Bryant cited is that the parties agreed that the husband or the wife would get 100% of the military retirement. That was an agreement in the case law that he cited. In our brief, we specifically cited several cases regarding military retirement, and one of them was the Kendrick case. And the court says, without cataloging each possible type of interest, we have concluded that pension interest that accrued during the marriage should be considered marital property, regardless of whether the interest is vested or non-vested, matured or unmatured, or contributory or non-contributory. The only requirement should be that the employee spouse acquire the interest during the marriage. And that's not at issue. The 74% of the military retirement that the judge equally divided or equitably divided was marital property, and that's not being contested. Mr. Bryan, in his opening, in his oral argument today, has said we're not contesting that the 74% is marital property. So that 74% is marital property, and that's what the judge divided. There's also another case, the Matthews case, and it's a military pension. The husband objected to many elements in the trial court's division of the marital property, including its division of military retirement income. We note that any interest in a retirement benefit, and it goes on, vested or unvested, that accrued during the marriage is marital property subject to division. In cases where the amount of the pension depends on the years of service, such as in the military, and those years overlap the marriage, the ratio between the years of marriage during which the pension accrued and the total number of years accrued gives us the most common formula for calculating what proportion of the pension should be considered as marital property. So the formula that the judge used was approved as appropriate in the Kendrick versus Kendrick case cited in our brief. So that's exactly what the judge did. And we just submit that there's adequate findings in the court's ruling. She specifically went through each and every factor. And Mr. Bryant indicates that it's not equitable, but there's no proof before the court saying there's not. There's no proof before the court saying that the wife wasted any money, that she hindered his career. They were both in the military. They both went from station to station. At one point, she was in Korea and he was at another station. They worked together. The military worked with them. So just because she got out and doesn't have a retirement doesn't mean that she shouldn't receive the 50% of the retirement that the judge ordered her. She got out because of an injury, and she has gone on even with that injury and gotten a degree using the GI Bill, and he's sitting at home smoking marijuana, not doing anything. So I don't think that there's any proof before the court that indicates that the trial judge was in error.
Thank you. You have additional time? You want to waive that, or you want to continue?
Oh, I'm done, Your Honor. Thank you.
Okay, thank you. Your rebuttal, sir?
Thank you, Your Honor. To the question that you posed to counsel earlier, I pulled Exhibit 2 of the trial exhibits, and that's the retirement account statement that shows what comes in per month and what are deductions. And it indicates that there is no survivor benefit plan elected with this one. Now, we deal with a lot of these in Clarksville. When a service member retires and they're married, both parties have to go and waive that survivor benefit plan. They have to sign the documentation. And apparently both of these folks did, because it indicates no SBP election on this account, and there's nothing coming out for it per month. So to answer your question, no, there's no survivor benefit plan. And like most military retirement, it would end, as Phillips said, upon the death of the recipient. Upon Mr. Grice's death, in this case, it would end. There's an important factual point that I want to make sure to mention. In wife's testimony, she specifically said that she is potentially seeking further work with the federal government. In this case, she mentioned the post office specifically, that she's looking into that she may do that. And the reason that's important is that if she does that, then her 16 years in the Army aren't for naught. Those are tacked on to her further government service. And if that is the case, then she may ultimately get a retirement from her service with the government, and likewise with the military. And if that's the case, then ex-husband, while he's giving 37% of his, is getting absolutely nothing from the wife's portion. And that was her testimony. That was one of her most potentially.
That would be an interesting issue to present sometime in the distant future, but is that something we can consider here today?
Since there was testimony about it, I think so. And in the future, I don't know that you could. I think if she went and got a job in the future, I don't think Mr. Grice, as much as he might try, could go in and modify that, because typically property division, like a retirement, isn't modifiable, unlike alimony. So if she was
totally speculative, though.
It is and isn't. I mean, is she definitely going to get that job? We don't know. But there could have been part of the ruling that made provision for that. There could have been part of the final decree that says, yes, I'm awarding this now, but if wife gets further government retirement based on her time of service while married, then we will make that adjustment. So that's it. Thank you.
Thank you very much. To the parties, I want to thank the attorneys for your presentation. Your case has now been submitted to the court. You will receive our opinion within a due course of time. Thank you very much. Madam Clerk, will you count it recess court until our next case?
This Honorable Court of Appeals is in recess until 3 p.m.